the participants to panel number 1. Welcome. It's 1 p.m. Okay, I think we can start. Thank you. So thank you for being persistent and continuing to be with us. I want to welcome you once again to the panel number 1, which is dedicated to competition, intellectual property, and economic growth, interferences and challenges. As you can see from the program, most of the presentations are in English, so we will start with the English. But when it comes to have a presentation in Romanian, I will try to facilitate the translation of this presentation. So far, from all those that are included in the program, we have only one speaker that have registered with a presentation in Romanian. So, Mr. Moisei, you will be the last one to present. So now I want to invite Mrs. Eurona Leka, which is the Executive Director of Albanian Institute of Public Affairs, Department of Governance, Politics and Communication of Marin Barleti University, Tirana, Albania, with the topic Competition Policy, Intellectual Property Right, Cornerstone of an Efficient Market Economy. Dear Mrs. Leka, the floor is yours.
Well, thank you for the invitation. Is it okay? Can you all hear me?
Yes, we can hear you, and we do see your presentation as well.
Okay, great then. First of all, thank you for the invitation. It's great pleasure for me being part in this conference, and I want to extend my highest appreciation for the organizers, and as well a big thank you to the outstanding speakers of the plenary session, which I really enjoyed. As you presented, I'm going to deliver a topic which is not easily enough, and it's kind of a challenge for me to do the delivering of that topic within 50 minutes. I'll try to stick to the agenda and to the timetable. The way how I'm going to do the presentation, it's going to be kind of a sort of theoretical way, which is the competition and how does the competition and the intellectual property per se do influence as a correlated concepts to the economic growth. When I'm going to do the presentation, mainly I'm going to be focused on the European Union and European Union legislation as during, as of the conference in the way or in another presented in its main topic. So I want to start with the competition in an open economy. All of us are quite aware that the competition is one of the main crucial elements in an open market economy. Nevertheless, the economists agree that the competition in its purest form does not exist. And even how there is a debate about its merits and demerits, advantages and disadvantages, for everyone, the competition in market economies is accepted as having more benefits than disadvantages. Today, there are about 125 jurisdictions that do have a competition law regime, and the large majority of them has, in the same time, an active competition enforcement authority. Regarding the European Union, absolutely, we do have the EU competition policy, which is advised by the Treaty of Rome in 1957. And in more particular, the Article 3 of the treaty and the Comma 3 states that the EU shall establish an internal market based on a highly competitive social market economy. So, absolutely, the rules and the way how the competition is done is governed mainly by the Council Regulation 1/2 2003, And the main aim of the competition policy is absolutely to safeguard the correct functioning of the single market. What does it ensure in essence? It does ensure that all the enterprises that do have the possibility to compete on equal terms on markets of all member states. And at the same time, it prohibits abuse of a dominant market position by one or more undertakings. So the competition policy as a whole does encompasses a wide range of areas, starting from antitrust and cartels, merger examination, state aid, liberalization of markets, and international cooperation, which is one of the main components of how the competition has been delivered on international basis. And absolutely, it is the European Commission that does enforces competition rules through its powers of investigation and sanction at the same time. The actors involved, there are a bunch of them, starting from national competition authorities and European Commission network, European Parliament, the Council of Europe, last but not least, the courts for sure. So does the competition influence to the economic growth or not? Absolutely, the competition is one of the main components for the companies to excel. So thereby, by fostering innovation, diversity of supply, and attractive prices for consumers and businesses alike. So the competition does stimulate growth. The competition stimulates and generates substantial benefits for the community as a whole. I have pointed out four main reasons that, I agree that, I think that most of the scholars do agree that the competition makes an economic growth. First of all, it is that we think in a more innovative way, and it is thanks to the competition. And secondly, thanks to the competition, we offer services with better quality. Third, we have better information to provide about customer preferences. And last but not least, it is thanks to the competition that we are highly motivated and we try to remain as a better business owner in the industry. By saying so about the competition, what can we tell about intellectual property? Is the intellectual property as important as the competition it is by itself? I should say that the intellectual property for sure plays an important role in what is promoting innovation and protecting investment, in particular in the digital and green economy. And that is why the European Commission as a whole works to harmonize and at the same time to enhance all the laws and bylaws which are related to the intellectual property right, and at the same time to ensure that a level playing field is available absolutely at the global level. So the intellectual property per se established a property right over what? Over an idea, which is the patent, over an expression, which is the copyright, over product quality, kind of trademark, design, plant variety. But the main types of intellectual property are the patents, the copyrights, trademarks, trade secrets, and the right of publicity. So as the competition, as well the intellectual property has its own ways to affect the economy. And which are those? First of all, by providing incentives to invent and to create. Secondly, by protecting innovators from unauthorized copying and facilitating vertical specialization in technology. And last but not least, by creating a platform for financial investments in innovation, supporting startup, and so on. So the stronger level of intellectual property protection in the same time facilitate what? The transfer of high technology goods into developing countries, thus increasing the stock of knowledges and raising in the same time the productivity growth, which leads to the overall economic growth. So by doing kind of recognition and the reward, which is associated with the ownership of invention and the creative work, we stimulate further inventive and creative activity, which in turn stimulate the economy growth. So the intellectual property absolutely have a vital role in the economies of developed and as well developing countries all over the world. It is through the intellectual property that all the consumers are allowed to make choices between competing entrepreneurs and the goods and the services that they do sell. Therefore, intellectual property is inherently pro-competitive as it ensures the protection of differentiated and intangible business assets. So without intellectual property, less efficient manufacturers and service providers would try to hook clients by copying the goods and the services of more efficient competitors, and the society as a whole will lose. So the intellectual property plays a crucial role of ensuring competition. So in the same time, does not only contributes to the growth, but in the same time ensures competition when the genuine differences within the competition are absolutely protected. I want to draw out a few conclusions how this intellectual property and the competition are deeply interrelated. We saw from the previous slide that both of them do contribute to the growth of the economy. But what is the most important thing is it is need to coordinate state policies in this field within the European Commission policies and as well in the global level. Intellectual property law and the competition law rules share the same objectives of promoting, innovating, and enhancing consumers' welfare. By promoting consumers' welfare, we do nothing than contributing to the economy growth as a whole. Their optimal combination will give an opportunity to bring the innovation activity to a new level because it helps to create incentives to attract investments and in the same time to create a favorable competitive environment for its realization. And furthermore, the intellectual property right promote a dynamic competition. Last but not least, I should emphasize and stress that intellectual property and competition, by encouraging innovation, they both make the cornerstones for the development of the economy as a whole. Thank you for listening. I think I strict in 15 minutes, but I am open for questions or remarks that the participants might have. Thank you.
Thank you very much, Mrs. Leka. Do we have any questions so far for our speaker? I just wanted to mention a few highlights of your presentation. You were mentioning about the ways how intellectual property affects the economy and contributes to fostering innovation and entrepreneurial activity. And how, what are those inputs or insights provided by the competition, providing benefits for the consumers, and why and how the interrelation between the competition and intellectual property contributes to the economic growth in the country. Mrs. Leka, I just do have a short question for you. As Albania is not yet a member of the European Union, what are those challenges that do Albania face in assuring that interference between the competition and protection of intellectual property right?
Okay, thank you for the question. It's really very interesting. Telling the truth, Albania is not part of the European Union, but we are part of the membership agreement. And by being part of the membership agreement, one of the main requests was kind of acquis community or adaptation within the Albanian legislation. So regarding to the competition and the IP, Albania has ratified all the European Union treaties and is part of the organizations when Albania can participate and have a voice in it. But as in all the Western Balkan countries, I can say, the competition is not as fair and the intellectual property is facing a lot of problems. Even how that the national authorities here in Albania are doing their utmost to face these challenges accordingly in order to create better conditions for the competition, a fair one, and as well to give the right to the intellectual about its own property right. But I mean, we are still in not very good situation about that, but we are dealing.
Thank you, Mrs. Leka. Before proceeding to the next presentation, I just wanted to inform all the other speakers that we can allow more time than was specified in the program, as just a screening of all participants to this meeting. We see that some of them are missing, so we might have more time for presenting and debating afterwards. So keep that in mind. Also, I do see one of the speakers from the second panel being present in this panel, domnul Badicu, Mr. Badicu, domnul Badicu. So, vă rog frumos să accesați, eu v-am lăsat în chat link-ul, dumneavoastră sunteți speaker în panelul 2. So I was just leaving the message that he has to access the other link to the panel number 2 because he's speaker in the panel number 2. Sorry for that technical details, but we're in here to make sure that everything runs smoothly. Thank you once again, Mrs. Leka, for your presentation and for your kind acceptance of our invitation. I want right now to invite the second speaker in our panel, Mrs. Oksana Holovko-Havrisheva, which is head of the Jean Monnet Center of Excellence of Western Ukrainian Research Center for European Studies, Ivan Franko National University of Lviv, Ukraine.
First of all, I need to unmute myself. Dear
Yes.
Vodika, thank you very much for the introductions, dear colleagues. Nice to have you here on the panel, and I hope that my contribution will also be a little bit interesting, of interest of all of you, because I am going to address a topic which is actually not very often addressed from the consumer competition law perspective, and even less addressed from the intellectual property rights perspective, and these are the consumer rights. I will just share my screen for a short presentation, and will be glad to share a couple of thoughts on the topics. On the topic I am going to address. First of all, the interest of this topic is coming up from my personal research interest, and that is about the consumer rights. And as far as you know, the consumer is considered to be the less empowered part of any business type relations. So when we are talking about the businesses and business relations, we have a clean distinction between customer, consumer, client, and so on. However, well, I was just wondering from that perspective that the consumers, in fact, are targeted both by the competition law and intellectual property protection regime. So they are like addressed both in a manner indirectly. So both of them, the competition protection is deemed to ensure that the consumer support as well as the intellectual property protection regimes are in the end effect ensuring also the issue of the consumer protection and the consumer regime from totally different perspectives, because but aiming at the same time at the possibility of the consumer to get the timely, reliable information to make the consumer choice. So and in this and from that perspective, the consumer rights agenda is really very interesting to be investigated on. Within the competition law mechanisms, which are aiming to the consumer, which are actually suitable to protect the consumers, this is by far a little bit different story, because all of those interconnections are placed, and in all the market assessment strategies and market definition, market share issues, the consumers do play an indirect but important role, because they, at the end effect, they determine the market power of any company. So the market share is dependent very much on the consumer behavior. Whereas in the intellectual property discussion, the consumer protection is actually very specific point, and is not that much addressed pretty much. But at the end of the day, each of us or as well can be treated as consumers within those regimes and the protection granted under the intellectual property legislation. There is a huge difficulty here in terms of the intellectual property rights, because intellectual property rights are dealing with the immaterial issues. So reading a book, can it be considered as consumption? Yeah. So those issues are really different and difficult. Watching a TV movie, are we considered to be consumers? So this is the discussion which is ongoing and actually relevant for the determination of the intellectual property rights attitudes to the consumer protection issues. And in terms of the particular issue that in current days, we are more and more dealing with the information as a consumer good in a big terms. So the consumers from the intellectual property rights perspective here can be at least addressed in 3 different dimensions, because when we are dealing and we are ending up with using the material protected by copyright related rights, we can use that in a simple manner as a consumer shoppers. Then actually the social media dimension makes us effective sometimes consumers, authors, because we tend sometimes to social media to modify products and to produce new products. And this is also the copyright issue for those relations and the kind of the information to be consumed. And the third dimension, I would say, because I have here the and consumer participants, because this was the distinction proposed because then that we are just sharing and the information for far beyond. In those all cases, we are dealing both with the active role of the consumer in dealing with the copyright protected materials, with intellectual property right protected material. My interest in those topic was actually merely linked to the research, however, how those issues are and how the copyrights, intellectual property rights, competition protection, and consumer protection, how they are regulated in the contractual framework between the European Union and the EAP countries. And here I just have the very short comparison, although the contractual obligations under the relevant treaties if they are present. And as you can see here, well, we have here Armenia, Azerbaijan, Belarus, Georgia, Moldova, and Ukraine compared so far. I will maybe make a little bit more more detailed. Is it easy to see? It is better to see right now?
Yeah, now it's better, but I was wondering if you can put the slideshow mode.
Yeah, just you have just to remind me.
Yeah, thank you.
Just a moment. Yeah, now it is working better. So just for me not to get confused. So I was trying to compare the obligations arising from the association agreements to put both, because protected consumer and protected businesses, they are both the initial part of the well-developing economy. They are inherently connected. So I was trying just to see, to make a map how those issues can be combined and regulated together. What came up to my conclusions? So we have here in the AP countries different attitudes of the European Union to the regulation of the relations with those countries. We have the outstander Belarus here, where the contractual relations are actually lacking, so that it's very difficult to research the impact. And there is the cluster cooperation opened, however, from my knowledge, from my understanding, it's very difficult to trace back the impact, for example, the EU standards in the relevant field influence in the Belarus. So this requires the particular research from that point by far much more than I did. And we have in the line here the Azerbaijan, who is also a different partner and stays out of the cooperation frameworks with within the EAP countries, because currently it is a country which has rather difficult relations and negotiations with the EU to develop or not to develop the new agreement. So this depends pretty much like in any Eastern European countries, so on the political dimension, on the political developments in the societies. And here the relevant document for the relations I discovered, this is the PCA agreement of the very first early generation agreements, which regulates both of those issues. And as to the Azerbaijan, for example, we can state that this is maybe the very loose regulation of of all three regimes, actually, on intellectual property rights, on competition cooperation, and on the consumer protection issues. Because these are mostly references to the framework obligations, which require further cooperations among the countries and the counterparts to develop the cooperation. The point here is that actually the instruments here, this is, for example, as to the Azerbaijan, there is a clause on the obligation to ensure the general clause to ensure the intellectual property rights protection by Azerbaijan, but there is no separate regulation on the competition protection. So there is like competition has been mentioned in several parts, but more details are lacking. And this is I wanted to move on the slide a little bit high up. No, it is not working.
No, Oksana, if you want to, I saw that your image doesn't fit into the slide. Yeah, you have to exit slideshow then. Yeah,
yeah, that's that was wondering. Again, this is the framework obligation to cooperate on the consumer protection issues. This is the early stage, and I would say really that the regime developed on the cooperation among the parties is really the framework agreement and the framework mode of the cooperation. Hereafter, we have in historical terms for association agreements with Georgia, Moldova, and Ukraine. And I was also trying to compare them with, in terms of the obligations that they are arising from the cooperation with the EU in those fields. What I just came up with several conclusions, because what is coming up, that the intellectual property rights issues are the most important for the cooperation. They are detailed, regulated by the association agreement directly in the text, in the framework. So these are the direct obligations for the states to comply with. And here the situation depends pretty much upon the national implementation practices that the states develop to apply those regimes. For example, in Georgia, in Moldova, we have the issue that the international treaties, like the association agreement, they have a direct effect. This is the constitutional provision on that. And compared to Ukraine, we do not have a direct effect of international treaties envisaged by the constitution. So then the delay of those provisions, of the implementation of those provisions becomes obvious, because in any time there is the implementation legislation needed to be adopted to comply with those obligations. So at least in the case for Ukraine, I can just, we have a very, very good governmental initiative to inform what is the progress in the implementation of the association agreement. And this is called Pulse Ugode. And you can just see of any of those issues, how far Ukraine proceeded. For example, by the protection of intellectual property rights is also very problematic for Ukraine. With a not high level of performance. The competition protection regime and the competition obligations as assigned by the association agreements, they are also very similar. You see that this is among the same short number of articles devoted to the issues, but the content is very important. So when we will be comparing the countries inside Georgia and Moldova have the more framework character formulations inside the association agreements. And for example, for Ukraine, we have quite extensive wording and regulations, and actually in the competition chapter, direct reference to the EU legislation Ukraine has to comply with. So this is a kind of, we have also here very detailed regulations on the state aid policies as much here. So again, the issue is, if I would just refer to Ukraine as a level of the implementation, it is a little bit about 50% of all EU relevant legislation has been transformed to the Ukrainian legislation already. The progress is depending on a lot of discussions and a lot of factors, because as well internally we deal with the same issue which goes across the EAP countries, and these are the problems of economic development. And again, the issues of compliance and seeing how those new standards to be implemented, they will work in the national environments of the EAP countries. And the final issue is here the consumer protection regime is also regulated by the association agreements in very spare number of articles. Again, these are the framework obligations. So here the annexes play a crucial role, and the state of implementation here depends pretty much upon the state cooperation. With regard to the up to my knowledge, actually, the hugest debate is here currently on adjusting the national consumer rights regimes to the EU standards. Moldova, I know, has adjusted it already. I think the law was of 2003 adopted the new Consumer Protection Act, whereas Georgia and Ukraine are lagging still behind. And due to internal political reasons, merely because this is the debate how to deal with the issue, pretty important. In Georgia, the question is that the libertarian approach to the government to the economic regulation issues actually predetermines a little bit that the consumer protection is put out of the primary priority cooperation agenda. In Ukraine, we have also the consumer protection out of the primary cooperation agenda as well. So here I would just say these are the differences which are ongoing. And the last but not least, Armenian agreement with the European Union, which recently entered into force, I think on March 2021. So this is really the newly entered into force. This is a type of the modernized partnership and cooperation agreement, and it reflects also the developments and sometimes mirrors the regulations embedded in the association agreements. But again, the level of the regulation is a little bit different. Maybe just to sum up, not to be extensive here too much, I would just say a couple of remarks. First of all, if we are comparing the association agreements of the EAP countries and the cooperation in those fields, the intellectual property rights agenda seems to be the most important one. Despite the competition protection and the consumer protection issues are less addressed. Not less important, but less addressed. I was put it in the way. Again, we shall bear in mind that all these countries have different approaches to the implementation of the association agreements. And very often the implementation is connected as well with the internal developments in the country. The implementation issues are connected over there, and this influenced that much. And last but not least, I was today very impressed by the presentation of a colleague of Matilda, who addressed the issue of the artificial intelligence, because all these provisions know how to deal with man-created, I would say, goods, products, services. But what happens in terms of the consumer protection issues when we are addressing the artificial intelligence debate right now? I would say here also that all these agreements which we have, Armenia, Georgia, Moldova, Ukraine, but also partly Azerbaijan have clauses on the adjustments to the European Union standards, which can be used, and that's why the standards are important. And the issue of the dynamic interpretation of the association agreements also allows to work with new developments in the EU law on those issues pretty much. So I hope that this will be the sheen which will be used in the future. Thank you very much for the attention. I really actually enjoyed working on this topic, because I never expected the interplay between the consumer rights and the intellectual property rights will be so important and debated as currently. Mosiva, am I open to any questions? Because I think I'm just overwhelming my time. There are a couple of other issues raised by slides, but I'm just leaving out that.
Thank you, Mrs. Havrisheva. Am I spelling correctly?
Yeah, a little bit difficult to spell out.
Oksana for me is easier.
Yeah, so just you can just call me Oksana. And
okay. Thank you. Thank you for your presentation. Indeed, at least for those countries that have already signed the association agreement with the European Union and are in the process of implementation, we do have that holistic approach towards intellectual property rights, competition, and consumer protection. But what I want also to mention is that in case of intellectual property rights, that holistic approach lead more to the international commitments of the countries and their participation into those international agreements rather than standing on national legislation or some European directives. Because even though we do have in Moldova, for example, Article 277 till 332 related to intellectual property rights, they are kind of very diluted, yeah? And most of them are referring to those engagements and commitments that Moldova has in international agreements, which is okay on the one hand, as soon as almost all member countries of the European Union are members of those agreements as well. But on the other hand, we do have the directives of the European Union that are so precise in terms of patenting, in terms of competition and interference between the patent and so on and so forth. So listening to you, I was wondering whether in Ukraine, at what stage there is the Ukraine in implementing first the association agreement, especially those articles related to IP, intellectual property right and competition.
Yeah, thank you very much. That's a really very good question, and I tried to tackle the issue a little bit in my presentation. There is really not very high progress to expect, actually not to expect, but currently done. So Ukraine actually managed to introduce the European approaches to the geographical namings and trademarks. But however, a number of other issues related to protection of authors' rights, copy-related issues, as well as sometimes trademarks, are at least by the pools required by the pool, this online tool, so you can just go and share and see the performance over the year, but all of them, those are not totally covered issues. So overall progress says about 50%. So the obligations have been already adopted. What is more confusing here that again, there is a huge need to inform about the developments. So I don't know how it is working in Georgia or Moldova precisely, but the information about the adjustment, as well as the information about the property rights issues, is actually not highlighted. It is not highlighting the public discourse in any cases. So it comes up to the sometimes to the protection, sometimes to it comes to the protection of trademarks again in such cases, but this is not the heavy public discourse in the society where the intellectual property rights are considered not to be complied with. Let us put it in those ways. So I would say those achievements are here not this part needs to be, in my understanding, modified, because it is essential also for the consumers. This information on proper trademarks, on geographical namings, these are the instruments helping to the consumer to make a choice, actually. So this is the link which is very obvious, but is not working.
Yeah, thank you, Oksana, for mentioning this. And I wanted to tell you this. This was one of the rationale of having this project in place. And I wanted to mention more than that. We do have another project that's in the final year of implementation that tackles the protection consumer and misinformation and I mean gathering information closer to the consumer about their rights, as also to the business environment about the role of using IP in and protecting and enforcing their business were one of the main reasons for applying to the European Union for the funding of this project.
Yes, we have several. We don't have, as to my knowledge, we do not have any intellectual property rights related project in Ukraine currently working. We have some, I think, two projects on consumer protection issues already from the last call of Jean Monnet, for example. So, but I'm not sure, but at least I remember to see one on the list. Just I was just tracing that pretty much. But again, here I would say that the problem is that within the respect of the consumer rights, that traditional consumer rights we do know from the material economy, I would say, yes, from stuff dealing with goods in terms of material goods. The right to repair, to refund, to replace, and so on, they are really really heavily modified by the fact that we are dealing with the intellectual property rights issues. So here again, when we will be comparing both those issues, I would say for protecting intellectual property rights and making the link, the right to information, the right to redress, and the right to damage, these are the primarily those consumer rights which need to be protected so far. So this is again, this poses the question, because in the digital era, how to protect those consumer rights. The consumer protection law mechanisms, data protection law mechanisms, competition protection law mechanisms, intellectual property rights protection mechanisms, question mark. So this is the discussion, I think, which might be interesting and determining also the future of the consumer protection legislation so far, because there is the picture is fragmented, and all of those aspects are actually present. So if you will trace back that to the national jurisprudence, you will just discover those issues that are the picture, as I say, is very fragmented.
Thank you so much, Oksana, for sharing your thoughts with us. And let's hope that more projects on consumer protection and IP will appear inclusively in Ukraine. Thank you.
Thank you very much, Rudika. If there are questions,
sorry?
If there are any questions, so I end my turn. Thank you very much for the attention.
Thank you. No questions so far in the chat. So I would encourage all the attendees of this panel either to leave the questions in the chat, and we'll have just to see how we do manage to organize ourselves. Yeah. Okay. Either please don't be shy, switch on your microphone and address directly the questions to the speaker. So yeah, as you can see, I want to invite the next speaker in our panel. It is Vladlena Lysenko, Professor, Dr. Habilitate of Shevchenko, Transnistrian State University. Mrs. Vladlena Lysenko is also contributing to this project. We do have a collaboration with her in this project. And today she will present, she will deliver a presentation on improving the practice of competitive strategies for protection of intellectual property from the point of view, a law and economics approach.
Radhika, thank you very much. Could you hear me? And
Yes, we do hear you. And
my presentation is online, right?
Yes, yes, yes.
Okay, so thank you very much again. And this is a really great honor and pleasure to be among very distinguished and very professional expert. And this is really unique opportunity because I represent Transnistrian University, and I'm not a practitioner in intellectual property law. I work mostly in the field of international public law, mostly working on confidence building measure programs between two banks of Dniester River. And today, maybe the title of my presentation is more general, but I will not make analysis of Transnistria or Moldavian legislation, but my presentation will be mostly based on three blocks. First, I made like a comprehensive analysis of situation with IP and competition law policy using important international analytical documents such as International Property Rights Index, World Intellectual Property Report, Global Innovation Index, etc. Also, in regard that pandemic crisis has illustrated dependence on European countries of Eurasian Economic Union countries on innovation and technologies, and reminded all countries about the importance of effective IP rules and tools. I shortly also will speak about very shortly about European Union strategy, what I found out during my analytical preparation for this conference, and also situation in Russian Federation. And intellectual property rights, of course, play a very important role in promoting innovation and protection investment, in particularly in digital and green economy. And as you see on the slide, International Property Rights Index is to build on 10 factors gathered under three components: legal and political environments, physical property rights, and intellectually property rights. And I will give some probably statistic. As you know, annually the International Property Rights Index ranks more than 130 countries, accounting for 94% of world population and 94% of world GDP. And as you might see on the slide, that according to that statistic, the overall scope is around 5.73. But the legal and political environment is the weakest component, followed by intellectual property rights, while physical property rights is the strongest component. And in this regard, Finland leads this index last year, as well as intellectual property rights component also for Finland, followed by America in that component. And Switzerland ranks as the second, followed by Singapore, who additionally leads the physical property rights component. And every year also the Global Innovation Index ranks the innovation performance of more than 130 economics around the world. And on that slide, you could see the 10 best ranked economies by income group. And in this group, you might see the global leaders in innovation last year. And also on the right, you also might see the positive tendency, the relations between innovation and development. And Moldova, Ukraine, and some CIS countries, you could see somewhere in the middle with the yellow circle, as you see, somewhere in the middle. And here is top of 25 global brands by value and region for the last year, brand value by level of economical development also for the last year. And speaking about top cluster ranking by publishing and patent performers, you might see also concentration cluster and non-cluster locations in the world on this slide, which is very much correlate what I previously said and what I showed on the previous slides, where you saw best ranked economies by the income group. This is for WIPO, some statistics that more than 28 of patent filings last year occurred in the IP office in China, American, Japan, Republic of Korea, and also European Patent Office. And China accounted of more than 40% of world total. And total application and growth in the applications, we see the patent filings worldwide declined by 3% last year, the first decline since 2009. Trademark and industrial design filing activity grew by 6% to 1.3 respectively. Patent filings around the world exceeded 3.2 million. Trademark filing activities totaled more than 50 million, in the industrial design filing activity amounted to 1.4 million. So this is a very interesting statistic. And which regions received the blank of IP fillings? Last year, Asia is the highest numbers of application for patents, utility models, trademarks, industrial designs last year, reaching this percentage which you see of the world respectively. This is, I wanted also to show global competitiveness report as a yearly report published by the World Economic Forum. And again, we see, I analyzed, for me it was not very often that I go to such international documents, but it's a performance of more than 140 world economies, and they're assessed on the basis on this global competitiveness index 4.0, and this reflects the ability to compete with other countries in the context of the fourth industrial revolution. Oh, sorry, fourth industrial revolution. And this global competitiveness report index, as you see, includes 12 indicators. Last year, for example, I saw where are Moldova and Russia, for example, in this rank. And last year, Russia remained, for example, 43rd among 140 countries in this global competitiveness index, and Moldova took place only as 86 on the 86th place. And as usual, I could say that Singapore topped last year, followed by the United States and Hong Kong third. And also on the top of 5, this is Netherlands and Switzerland. Let's say about the problem of coronavirus, the disease, pandemic that triggered a very unprecedented global economical shutdown. And the current crisis hit the innovation landscape at a time when innovation was flourishing. And according to the latest estimates, as I found, the economical and health crisis triggered by COVID is expected to push around 100 million people into extreme poverty for this year and for the next year. And what were the market-related priorities emerging from the past decade? As you see, the financial systems after the 2008-9, as you see, crisis have become sounder for many economics for this period of time. And market concentration has been on the increasing trend in the advanced economy. So innovation has also become concentrated. Most other countries produce only marginal innovations or local adaptation of existing technologies, as about trends in patent concentration. Just as I already said, 5 countries today produced together over 70% of global patent activity, and other 10 countries generate over 85% of global patent shares. These levels of concentration have remained in place for the past 20 years, with the exception of China and Korea. And what are, I could say, priorities for turning markets into proactive levels for achieving the transformation of the economy? And on my opinion, or how did I found that 6 conditions of my opinion need to be in place: develop markets to materialize, which is invention, production, demand, standards, codification, infrastructure. I shortly would like to mention the pandemic situation. It has illustrated dependence of European Union countries on critical innovations and technologies, and reminded Europe of the importance of effective IP rules and tools. And as example, international property rights and their role in a competitive and innovative European, for example, pharmaceutical industry, also became a part of new pharmaceutical strategy for Europe, which is also recently. And analyzing the conclusions from European Union Commission to the European Union Parliament, the Council suggested an intellectual property action plan to support European Union recovery. And I put on the slide 5 challenges, identify 5 challenges. Despite of a lot of progress, part of European Union IP system remains too fragmented, as already many colleagues already mentioned about this. Second, too many countries, in particular small and medium enterprises, and too many researchers do not make full use of the opportunities offered by IP protection. Tools to facilitate access to IP are insufficiently developed, lack of fair play at global level, and EU businesses often lose out when operating abroad. And to improve the way international property rights are protected in the European Union, European Commission will support, of course, a rapid rollout of the unitary patent system, optimize the supplementary protection certificate system, modernize European Union legislation on, for example, industrial design, strengthening the protection system for geographical indicators for agricultural products, evaluate the plant variety legislation, etc. I'm a little familiar with Russian legislation just because I was studying there, Moscow Lomonosov University, but so we are familiar with Russian legislation. And I would like very shortly to speak about the anti-monopoly policy, which aims to ensure competition by using methods of controlling the level of market concentration, prevention, stopping abuse of dominant position in the market. And so I reset the situation with competition in the Russian Federation as well, antitrust regulation and protection against unfair competition. But problems in the sphere of intellectual property rights protection in Russian Federation continue to be a reason for criticism of the Russian institutional environment from developed countries. Especially this criticism was in terms of Russians entry to the World Trade Organization. And according to the annual report of World Economic Forum, Russia, unfortunately, is on the 126th place from 142 countries for the indicator of intellectual property protection, for example. And in general, we may say that there have been no significant changes, except some maybe changes in legislation and the situation with the competition in the Russian Federation towards its recovery and development. And the key problem that hinder the development of the economy, competition, improvement of the quality of goods, and reduction of their cost of the customer, I put on the slide. But besides those problems which are on the slides, I would like to name another. For example, an urgent problem is the counting of the counterfeit products when assessing the situation with the competition in the product markets as necessary condition for the application for certain key norms of anti-monopoly legislation. A significant share of state-owned economic entities in the Russian economic also continues to be a factor that negatively and very negatively affects the development of competition. Then anti-competitive agreements, including the most dangerous type of them, are cartels. Cartels are widespread in all sectors in Russian economic, including those of strategic importance, like we know such cartels as a distribution and extraction of water, biological resources, supply of medicines, food, and another. Also, I would like to say that a specific feature of anti-competitive agreements in Russia is the participation of state bodies, organizations, and officials, the performance of the act by public servants that contains signs of crimes. I mean, this statistic or this I found in different reports, also official reports, and this sign of crimes like bribe, thefts, abuse of power, in order to conceal or ensure the conclusion and fulfillment of anti-competitive agreements. So thus, last year, the anti-monopoly authorities initiated more than 300 cases of the conclusion of anti-competitive agreements with the authorities. And cartels are breeding ground for corruption, as I already said. And in general, I could say that, yes, there was the process of development, legislation and enforcement practices in the fields of competition in the Russian Federation. Again, as far as I found this in official different statistic researches, and this was many cases last year in which under the Russian law, unfair competition is prohibited when a business entity performs acts that can cause mixing with the activities of competing economy entity or with its goods or services, including illegal use of a designation that is identical to trademark, copying or imitation of the appearance of the good, its labels, names, colors, brand styles, etc. So I found many cases of infringement of Russian legislation in this regard. And just maybe last general, I could say, a conclusion which made based on, let's say, based on the analysis of legislation and enforcement practices in the sphere of production, circulation, and protection of intellectual property in Russia. Sorry? Yeah, I am already finishing. And other Eurasian countries. So there are still fundamental differences. And so such differences as a system of protecting intellectual property items, determination of the right holders of the results of intellectual activity, scope of rights to results of intellectual activities, mechanism of civil, legal, and customs protection of intellectual property, etc., etc. So you might see this short analysis or short conclusions on the slides. And I want to stop now and say that, again, I'm not a very big practitioner in this field, because for me it was a little a new topic, even I could say. And I want to thank you, and would like to say that Transnistrian University and our colleagues are, let's say, was a small part of this project, and we organize a number of seminars for our youth, just for them to understand the idea of harmonization of all these standards and problems during that time. So thank you again very much, and very much hope for continue this cooperation. Thank you.
Thank you very much, Vlada, for your presentation. I don't see any question in the chat, but I would encourage all the attendees, whether do they have questions, leave in the chat. Either I would ask every time after each presentation whether you do have questions. So no questions so far, Vlada, thank you. We will continue with a very interesting presentation related to the industrial property and investment in research and business sector, a comparative study between Czech Republic and Poland. We do have as speakers, two speakers representing the both countries compared in the study, and namely Smetansky Roman, which do represent the Pole University of Technology from Poland, and Andrea Tomaskova, University of Finance Administration from Czech Republic.
So
I see both. Yeah, I see both of you. Yeah, but ladies first. I do understand. Yes.
So I'm trying to share my presentation, and I'm click share, and so it's some share screen. So please, can you help me? What I have to share? I'm share.
You share
green,
the screen. You press that green, yeah.
Green square, yeah.
Yeah. Then you have to. There is a window that pops up, and you have to select what you namely want to share.
So I'm confirm my presentation.
Yes, it's uploading right now.
Do you see presentation now?
Double click on it. Double click to enter the full screen mode. It's right.
So double click. So new share. So my screen, I see my presentation.
No, we see your screen, but it's black.
So
Maybe your colleague can help you, Roman Smetansky. Do you have the presentation as well?
Andreo, to je ta, której są mi poslala prezentację.
I was just wondering if you can send me the presentation.
So
maybe I can
just
help
now
you.
I don't hear you.
You don't hear me? Roman, maybe you can try to share the screen.
Yes, I try. I don't know. It's okay now.
Andrea, can you stop sharing your screen? We do apologize, but this is all the times when you are not meeting in front of each other, but we are using these technologies. No, I'm written in here that both of you are trying to share the screen. So could you both of you stop sharing your screen and
to make someone with my with my PC.
okay.
Is it possible to interrupt my sharing and send my presentation via chat?
This is what I'm trying to, no. Okay, now, Roman, if you can try sharing your screen. Yes, that's fine. We can see it.
Maybe.
No, go back, close it. Go back to the previous presentation that you had. Okay, that's fine. Roman, Andrea? We don't hear you. So what we will do, in order to avoid, to overcome this situation, I would kindly ask Romana or Andrea to send me the presentation. So we'll skip you, we'll move forward to the next presentation. Okay, now it is written that Roman is out of the meeting. Roman, can you hear us? Can you hear us, Roman? No, you have to switch on your microphone because we cannot hear you.
Yes, I am. Okay.
Do you want to share, to try to share your screen?
I don't know how.
Yes, we can see it.
Yes?
So it's fine.
Mm-hmm.
So yeah, leave it as it is. So who would be presenting, Andrea or you?
Andrea, yes, Andrea. Because my English is not good. Andrea,
Okay.
speak better.
Now I was just wondering if Andrea is still with us.
Mm-hmm.
Andrea? No, she's out. Okay. Roman, probably we will skip your presentation and we'll come back. We'll leave the next speaker to present and we'll come back to you.
Mm-hmm. Okay.
Sorry everyone for this technical issue. It might happen sometime in the digital era, you know. Now I want to invite Julian Moraro, which is representing Moldova State University as a PhD student, but also working for Competition Council of the Republic of Moldova, with the topic of discrediting of competing trademarks between multiple qualification option and qualification impairment. Julian, the floor is yours.
Thank you very much for the floor. I would like to kindly ask the participants if my presentation is accessible to you now.
Yes, it
okay.
is.
So today I'll present my research on the topic of discrediting competing trademarks as a multiple qualification option and qualification impediment, and I've chosen a related image for my presentation as disparagement, because of the fact that disparagement has the same meaning as discrediting. In general, in English, there are lots of alternatives for for the word of discrediting, as disparagement or denigration, and so on and so forth. They are all synonymous and all have the same meaning. In consideration the Moldavian legislation, there are I have found 4 forms of competing trademark discrediting. It's competitive discrediting, which can be both direct or indirect discrediting, denigrated advertising, and comparative advertising. Direct and indirect discrediting are qualified or can be found out in the Article 15 on the competition law number 183 from 11th of July 2012. And denigrating advertising and comparative advertising can be found in law on advertising number 1227 of 27th of June 1997. I have found out during my research certain distinguishing criteria between competitive discrediting and denigrating advertising and comparative advertising in order to offer a practical approach in this sense for awarding the other practitioners and also the theoreticians to qualify in a proper way. The infringements of the law. So I have brought 5 criteria in this sense. Sorry. I have brought 5 criteria in this sense. So can you hear me?
Yes.
Okay. So that competitive discrediting imperative implies the existence of false information, while disparaging advertising may even contain truthful statements.
Jan, can you start once again sharing your presentation? Yeah.
Is it okay now?
Sorry.
Yeah, it is okay.
So that the second distinguishing criteria between qualification as competitive discrediting or denigrating advertising consists in the fact that competitive discrediting may involve the spread of false information by transmitting it to a single person, while advertising is usually accessible to an indeterminate number of consumers. Apart from that, another criteria of distinguishing between competitive discrediting and denigrating advertising relies on the fact that competitive discrediting is a formal action that sufficiently involves the spread of false information, regardless of the existence of any effect or injury, while disparaging advertising involves the actual damage to the honor, dignity, or professional reputation of a competitor as a result of accessible advertising for an indeterminate circle of consumers. As well, competitive discrediting involves 2 alternative ways of manifestation, direct and indirect discrediting, while denigrating advertising can only affect the competitor directly. At the same time, comparative advertising may involve interferences with the indirect form of discrediting of a competitor. And last but not least, competitive discrediting is an active action, while disparaging advertising is usually a passive action provided that the producer, supplier, or broadcaster of the such advertising are involved in a single act, which implies a subsequent passivity of a producer, supplier, or broadcaster in relation to the named advertising material. Of course, in practice, from a practical point of view, there are no ideal situations in which the certain law infringements can be qualified either by norms of unfair competition or by norms of unfair advertising. And in these situations, we may either have situations of conflicts of qualification or accumulation of illicit acts. In my research, in my full paper, I brought certain examples of both of conflicts of qualification and accumulation of illicit acts, and also I brought some proper resolutions in order to solve such conflicts or situations in which there are accumulation of illicit acts, and it depends actually on the offer of notification, as taking consideration the fact that the the authority to solve such situations is Competition Council of the Republic of Moldova, and another relevant criteria in order to distinguish between denigrating advertising and competitive discrediting in situations in which there are certain conflicts or accumulation of illicit acts. Until now, I have described general situation in this sense in the Republic of Moldova. But also I have studied in my research the international trends in this sense, and I have found out that actually discrediting competing trademarks is assimilated to comparative advertising in the European Union. In our country, in the Republic of Moldova, comparative advertising and discrediting competing trademarks are two distinct law infringements. But in European Union, in most cases, discrediting is assimilated to comparative advertising, taking into consideration the fact that actually in the European Union doesn't exist unfair competition, or it is mostly related to intellectual property and consumer protection. So in this sense, there is directive number 114 from 2006 of the European Parliament and the Council of the 12th of December 2006 on misleading and comparative advertising, which expressly indicates, in which is expressly indicated in the Article 4 that the comparative advertising shouldn't contain any statements which discredit or denigrate the competing trademarks of a certain competitor. So in the European Union, the discrediting of competing trademarks is related to comparative advertising, and in most cases they are assimilated. Also, I have studied certain relevant practice at both national and international level. So at the national level, the most relevant case, in my opinion, is Simplex Co versus Viloterm, which was solved by the Competition Council of the Republic of Moldova in the year 2020, last year. And there, in this case, there was determined by the Competition Council the fact that Viloterm has infringed the competition law, namely the law, the Article 15 of competition law, by discrediting the products of Simplex Co or discrediting their trademark, which is registered to their name, which deals with the trademark Baxi. So Viloterm has spread false information concerning the activity of Simplex Co, concerning the quality of the products which are delivered by Simplex Co on the territory of the Republic of Moldova, and therefore the Viloterm company was applied a fine, and was determined to have infringed the competition law, namely Article 15. At the international level, namely. There is a very relevant case, British Airways versus Ryanair Limited liability partnership, the case which was solved in 2001. Ryanair Limited has spread false information concerning the activity of British Airways. Specifically, they have spread false information concerning the fact that British Airways only have been selling only expensive tickets, flying tickets, and they called them expensive bastards. And they have published this statement in many newspapers, as well as in the United States of America and abroad, and also in the United Kingdom. And they have been determined to have infringed the law on advertising, therefore. And apart from that, another international trend, I haven't indicated this fact on the slides, but I can tell about it in this way, but in many states, disparaging statements concerning competing trademark also can be qualified through the provisions of trademark protection. So we have three main ways to qualify such actions. We have through the norms of fair competition, through the norms of denigrating advertising, and through the norms of trademark protection. and it depends on the all relevant circumstances to the case in order to qualify certain infringements in a certain way. From my point of view, as a result of my research, I have come out to 5 main conclusions, general conclusions following my research. So first one, the discrediting repeated brands implies the existence of multiple qualifying options. It was the first idea to which I came when I started my research, and afterwards I found out that the respective qualification options are dispersed in distinct normative acts in our country, in the law advertising and the law on competition. The regulatory dispersion in question is likely to cause qualification impediments to the Competition Council as an authority to solve such cases. There are jurisdictions in which the discrediting of trademarks is an infringement, including based on the provisions of trademark protection legislation, and listed at last, defining the criteria for delimiting different qualification options is a crucial aspect in order to achieve a correct qualification of the conduct of enterprises in their economic activity. Thank you very much.
Thank you very much, Ilian. We see that what are the spillover effects, of those interferences between competition and protection of IP laws, and how discrimination and denigration competitors come in between. Thank you very much for sharing with us your research results. Any questions? If there are no questions, so we'll try once again with Andrea. Andrea, can you try sharing your screen? Thank you very much, Ilian.
So I'm sharing my screen. In case of emergency, I'm
Yes.
sent my presentation to
Yeah.
so.
But let us try you first.
Mm-hmm.
If not,
Yes.
I will.
Mm-hmm. Sharing.
Yes, that's fine. It's working.
Oh. Thank you for actual. Thank you for inviting to this conference. I will present you contribution with my colleague Roman. Our contribution is about intellectual property and investment into research in the business, comparing Czech Republic and the Poland. There is a declining trend in Czech Republic between the years 2015 and 2019 in the granted patents in the Czech applicants. The situation is completely opposite for foreign applicants. In this most 10% annual increase compared to domestic Czech entities, foreign applicants have 8 to 10 times more patents. In year 2019, it is even 15 times more for patents. So foreign applicants were mostly from Slovakia, Germany, Austria, and Poland. It is clear that there are significantly more utility models and granted patents. In this fact, due to the fact that obtaining utility models is a significantly simpler, faster, and a cheaper method of protection than in case of the patent. However, in the case of patent, this is a stronger form of the protection. Entities that registered patents and utility models are, for example, public research institution, means Academy of Sciences, departmental or enterprises, domestic companies, or foreign affiliates, or individual entrepreneur, or others entity, means hospital, association, or non-profit organization, governmental and public organization. Depending on the time of applicant, the predominant entities are company, individuals, and public universities. In the case of patent, there are a declining trend in all entities in the years 2015 to 2019. In the case of utility models, there is a declining trend in the public universities, company, and individual. On the contrary, there is an upward trend in public research institution. On a total of 2,090 patents were filed between years 2015 and 2019, the most in the year 2016 and least in the year 2019. And in case of utility models, in total is more than 5,600. And there are some information about expenditure on research and development and the share in gross domestic product. It has been a long-term increase in expenditure on research and development in the Czech Republic. In year 2019, for a second year in a row, expenditures exceeding about more than 100 billion. It spends Czech around more than 102 billion on the research and development in the year 2018, and more than 111 billion in year 2019. In relation to gross domestic product, research and development expenditure in year 2018 increased from 1.19% to 1.94% in year 2019. Within the European country, Czech ranks stands behind the Netherlands and Slovenia, but surprisingly, for example, ahead of the United Kingdom. 10 years ago, the Czech Republic was 16. However, the Czech Republic are still losing out to the most developed European countries. Situation in Poland. In Poland, there has been a rising trend of investing in the last few years. In a particular, investment has been increasing regularly since year 2017 by 15% annually. The share of investment in gross domestic product is also growing. In year 2019, it reached 1.32%, and the amount of investments was more than 30 billion crown. So the next slide introduce workplace on research and development in the business sector. For many years, it has been true that the business resources have the largest share in the financing of research and development in the Czech Republic. The last year, it was especially 58%. In the year 2019, the company invests almost more than 605 billion Czech crown in research and development activity from the resources, mainly in their own in-house company for research and development. Situation is in Poland. The share of entities in research and development is increasing every year. Workers from the higher education sector and the business sector predominate. There is a minimal representation of persons who participate in research and development from the sector of private non-commercial institution and the governmental sector. Regarding research and development investments in the business sector, private entities predominate, followed by the public domestic and public foreign companies. in the year 2015 to 2019, an upward trend in the number of research and development workplace in all sectors can be seen. It can be concluded that the rising rate of investments will reflected in the increasing trend in the number of utility models and patents in few years. Simultaneously with the number of research and development workplace in companies, investment in the research have been increasing in a recent year. In year 2019, nearly 70 billions was invested. More than private Czech domestic company invest private company under foreign control. The investment in research and development accounts for almost nearly 65% of all investment. Investment of domestic company account for almost nearly 32%. Internal expenditure of research and development in Poland significantly dominate in the governmental sector in year 2015. In year 2016, expenditure fell sharply and still have a declining trend. On the contrary, in the corporate sector, it rose sharply in year 2019. Expenditure, research and development is also growing in the higher educational sector and in the sector of private non-commercial institution. So we can state that investment in research and development in Poland are growing in all sector. In Czech Republic was made research from the Association of Small and Medium-Sized Enterprises, and it was a very interesting result. Most companies plan to innovate in the coming next months, more often into technology, simplification of administration, into product, self and education, and into production process. In this this is a classic development. Companies know that they cannot afford stagnation, but unfortunately, in the recent year, investment in innovation has been hampered by illogically high wage and lack of capable workplace, because in Czech Republic is actually low rate of unemployment, but really actually is a problem due to pandemic situation. And in what areas will innovation will be directed? Innovation will most often be aimed at strengthening overall competitiveness, for expanding products and services, for regular investment in business development and product and services development, for automatization, digitization, and addressing shortcomings workplace. The issue of labor shortage is a long term. When I mention Czech Republic has a low unemployment rate, is it clear that the market has shrunk and consumption is falling slightly, and consumer is waiting for situation to develop? This leads companies to think about how to balance decline and how to gain a competitive advantage. For financing, research and development company will use their own resources, financing to bank loans, subsidies, or intercompany loan and foreign capital, or the entry of the Czech investor. Actually is prepare for the company some specific packages due to pandemic situation to restart own business, and consequently can start new amount of money to research and development. Stable business is essential for companies' investment in the research, the country's environment, and it is a clear long-term strategy. The innovation strategy of the Czech Republic for year 2019 to 2030 names a country for the future. Is it said in the Czech Republic can be used as an example how to support research and development, and linked several kind of industry, others entity, for example, association, government sector. This strategy has 9 main pillars, and the first pillar is for financing and evaluation of research and development. The aim of strategy is among other things, of course, to prepare a fundamental amendment to the Act on the support for research, experimental development, and innovation, which would better reflect the level that the Czech Republic wants to achieve, and significantly strengthen funding for research, development, and innovation from 1.79% of gross domestic product in year 2019 to 3% of GDP in the year 2030. Thank you for your attention. So it's good.
Thank you very much, Ms. Tomaskova and Mr. Smetansky. It was really interesting to see a differentiated approach, a comparative approach between the two countries. Yeah, and it's really, I do believe that's really important to research investments in business sector, because these are the source of innovation and later on subjects to register intellectual property protection. Thank you very much. Any question for this presentation? So no questions so far. Thank you so much. I just want to, once again, before giving the word to the next speaker, Mr. Andrei Moisei, which is representing the State Intellectual Property of Republic of Moldova. He will speak about the role of trademark in promoting products in the competition fight, yeah, between the competitors. He'll present in Romanian. But meanwhile, I just wanted to announce all the participants about the possibility of publishing your results, research results. There is a for the English version of the articles, there is Eastern European Journal of Regional Studies. I would just leave them in the chat the link to the journal. And also for the deadline for accepting articles in the Eastern European Journal of Regional Studies is end of March. So you do have still 2 weeks to work on and finishing your research articles. You see in the chat the link towards the journal. For the Romanian version of the articles, you can consider publishing in Intellectus Journal, which is a journal of the State Agency on Intellectual Property. So I give the floor to Mr. Moisei. For all our international participants, Mr. Moisei will present in Romanian, but at the end of the presentation, I will just present a summary in English of his presentation. Thank you for understanding. So, domnul Moisei, aveți cuvântul.
Bună ziua! Regret faptul că nu cunosc engleza în măsura în care ar fi posibil să realizez o prezentare, dar asta e situația. Deja posibil pentru mine e depășită engleza. Eu, de fapt, am o prezentare destul de succintă, fiindcă anul trecut, noi am vorbit despre concurență, am vorbit despre concurența neloială, despre efectele concurenței. Mi-a plăcut foarte mult prezentarea reprezentantului din Ucraina, reprezentantei din Ucraina cu referire la faptul că ați văzut triungolnicul ăsta unde avem protecția consumatorului, avem concurența și protecția concurenței sau concurența și avem proprietatea intelectuală. Deci sunt trei factori care sunt foarte strâns legați între dânsii. Deci eu nu o să mă refer la concurență în special, fiindcă am menționat deja că am vorbit, eu o să vorbesc despre marca în contextul concurenței. Noi am vorbit și nu odată am vorbit că în lipsa concurenței nu poate fi vorba despre protecția proprietății intelectuale. Protecția proprietății intelectuale își are sensul doar în cazul în care există o concurență. Există o concurență sănătoasă. Eu am captat careva imagini din perioada sovietică, care le mai ține minte, care nu are posibilitatea să deschidă Google și să vadă toate informațiile respective unde era ignorată concurența. Și avem, dacă observați, avem diferite indică. Noi nu avem practic, nu era probleme, protecția consumatorilor era realizată, concurența nu exista fanionul transmisibil. Deci este foarte important anume concurența în contextul protecției proprietății intelectuale. Avem o imagine. Despre cine vorbește imaginea respectivă? Avem un telefon retro, depășit, avem un telefon roșu. Și ce mai putem spune despre telefonul respectiv? Mai nu avem informații despre telefon. Și atunci, despre cine vorbesc mărcile respective? Noi aici nu avem un telefon, dar noi suntem siguri că este vorba de un telefon și nu doar de un telefon. Noi cunoaștem foarte bine cum arată telefoanele Nokia, noi cunoaștem bine cum sunt telefoanele de la Samsung sau de la Motorola. Noi vedem telefoanele respective, noi știm care sunt capacitățile telefoanelor respective. Este foarte important, anume în considerentele că companiile respective au o concurență sănătoasă, este foarte important pentru consumator. Și atunci apare altă întrebare, dar de unde consumatorul cunoaște lucrurile astea? Noi nu avem imaginea telefonului, dar dânsul cunoaște că e vorba de un telefon. Noi nu avem capacitățile lui, dar dânsul cunoaște care sunt capacitățile. El are posibilitatea să facă o alegere. Asta este rolul mărcii. Și atunci altă întrebare, dar cum ajunge informația respectivă în marca dată? Pentru că atunci când vorbim despre producători autohtoni, suntem consumatori. Avem posibilitatea să mergem în market, avem posibilitatea să mergem la cumpărături, la piață, etc. Și de fiecare dată noi suntem puși în situația în care regăsim pe ambalaj absolut tot ce îți dorești. Informații care și mai de care. Că e foarte gustos, că e foarte sănătos, că e eco, că e bio, că e nu știu de unde. Aici noi nu avem informații. Noi nu avem la Nokia în imaginea respectivă informații despre faptul că este vorba de un telefon. Nu avem informații despre faptul, dar noi cunoaștem lucrurile astea și asta vine din promovarea produselor. Fiindcă iarăși, când vorbim despre concurență, dorința producătorilor este sau tendința producătorilor este de a comercializa, de a capta consumatorul, de a reține consumatorul. Făcând-o într-o concurență sănătoasă, el are perspective, are succes. Cu regret, marca Noi cunoaștem care este. Eu nu o să mă refer la noțiunea de marcă. Noi știm ce este marcă. Este un semn care permite să identifice produsele, etc., etc., având funcții extraordinare. Uitați-vă care sunt funcțiile unei mărci. Funcția de diferențiere, funcția de concurență, pentru că iarăși noi vorbim despre telefonul respectiv. Atunci când noi avem marca în față, noi avem și funcția de diferențiere, avem funcția de reclamă, avem funcția de protecție a consumatorului, fiindcă prin marca respectivă noi de fiecare dată regăsim calitatea la care noi ne așteptăm, calitatea dorită. Consumatorul are posibilitatea să facă alegere. Funcția de monopol. Funcția de monopol prin intermediul asigurării drepturilor exclusive asupra protecției mărcilor. Da, eu nu vorbesc despre proprietatea intelectuală în ansamblu, fiindcă fiecare obiect de proprietate intelectuală își are rolul lui în condițiile concurențiale. Noi o să vorbim ulterior, poate la ediția următoare, despre rolul brevetelor, rolul invențiilor. Astăzi ne oprim doar la rolul mărcilor. Am reflectat doar două funcții importante, funcția de concurență și funcția de protecție a consumatorului. Funcția de concurență fiind un mijloc de individualizare a produselor, marca servește drept instrument de atragere a clientelei, de reținere a clientelei. Cât privește informația captată în marca respectivă sau informația care noi o cunoaștem văzând imaginea unei mărci, nu este altceva decât rezultatul promovării și companiile investesc foarte mult în promovarea produselor. Care e situația reală în Republica Moldova? Noi nu putem să spunem că avem o concurență sănătoasă. Noi nu putem să spunem că producătorii autohtoni nu sunt inovativi. Ei sunt foarte inovativi. Cu regret, inovația producătorilor autohtoni vine mai mult de pe poziția cum ar înșela consumatorul. Și noi din fiecare zi, fiind consumatori, de fiecare zi ne ciocnim de aceleași probleme, chiar și axându-ne pe producători cu tradiții, pe producători care țin la calitatea produsului. Și atunci apare întrebarea, dar unde este cultura? Noi nu avem cultură în domeniul proprietății intelectuale, noi nu avem cultură în domeniul concurenței, noi nu avem cultură în ceea ce ține de protecția consumatorului. Noi avem o legislație extraordinară, noi promovăm, noi suntem membri la toate convențiile și tratatele internaționale pe domeniu. Noi avem enforcement-ul de poziția normelor legale și persoanelor competente în domeniul ăsta. Totodată noi nu avem. Și atâta timp cât, și eu salut foarte mult lucrările, atâta conferințe respective, cât și a oricăror altor tendințe de a ridica măcar cât de cât cultura în domeniul proprietății intelectuale. Cultura în măsura în care noi să avem o concurență sănătoasă, fiindcă dacă o să avem o concurență sănătoasă, noi am să avem asigurată protecția consumatorului. Și respectiv o să avem succes de pe poziția proprietății intelectuale. Și să conștientizăm despre faptul necesității protecției proprietății intelectuale și rolul mărcilor în lupta concurențială, care este foarte important. Și nu doar a mărcilor, am spus, rolul proprietății intelectuale. Și doar în situația respectivă, dacă noi să ridicăm cultura generală pe domeniile menționate, noi o să avem un succes nu doar în contextul protecției consumatorului și produselor de calitate, produselor competitive, dar o să avem și un succes de poziția producătorilor care o să reușească să comercializeze produsele nu doar pe piața autohtonă, dar și în străinătate. Eu vă mulțumesc pentru atenție, nu o să vă rețin mult. Dacă sunt întrebări, cu plăcere pot să vă răspund.
Mulțumim, domnul Moisei. For English-speaking attendees, I just want to briefly mention the main ideas of the presentation of Mr. Moisei. He talked about trademarks and competition and how the importance of innovation in spurring the competition. He started with a few pictures in Soviet times when there is a very low degree of competition and therefore no innovation, and all the signs to differentiate were almost non-existent. So there was no place for trademarks, yeah, because everyone was the same, producing the same, and they were not fighting for distinguishing themselves on the market. Then you saw the telephone, yeah, the product telephone, and Mr. Moise said, when we look to the goods, then we cannot see too much, yeah, because it is a good. We can say that it is red, that you can use it to reach someone, but you cannot say too much about the good. But when we look at different trademarks, then we can say more than simply looking at the good. Yeah, we know what kind of telephones each company under this trademark is produced. What are the features? What are the technological characteristics? What is better? What product is worse, and so on and so forth. So trademarks can tell us more than even the good. So it's very important for the companies to use trademarks in assuring the competition in the market and ensuring their place in getting and accessing the consumers. He mentioned about all functions that a trademark has, and namely the function of differentiating on the market, the function of competition, protection of consumer, guaranteeing the quality, organizing the market, the function of monopoly. But later on, he focused only on two of these functions, and namely competition and consumer protection. So competition, there is always the fight between the producers to fight for their consumers in the market. And in these processes sometimes companies comes to cheating, yeah? They do everything just to gain their consumers. And here he mentioned the main message: we lack the culture of IP protection and the culture of competition. And we need to have more events that are oriented towards nurturing and building this culture of IP protection and competition. And at the end, he says that trademark plays a really crucial role in assuring fair competition and protection of intellectual property rights. Thank you.
Thank you very much.
Mulțumesc, domnul Moise. So we will proceed. So we do have a message in the chat. I'm trying to read it out. Yeah, Mihaela says, okay, there is not a question. She's just informing me that she's not ready to present. So we are moving forward. We still do have two more presentations. And now I do invite Ilie Santa Maria. She will talk about in her presentation about effects of counterfeiting the trademarks. Her presentation will be also in Romanian, but at the end I'll proceed with a short summary in English. Ilie Santa Maria cu prezentarea efecte ale contrafacerii mărcilor.
Bună ziua!
Bună ziua!
Îmi spuneți, vă rog, dacă se vede prezentarea?
Da, dacă poți să o mărești la nivel de un slide, pentru că noi vedem... Așa, e bine așa.
Da. Deci, eu o să prezint tema efectele contrafacerii mărcilor. Deci, ce este contrafacerea? Contrafacerea unei mărci comerciale reprezintă actul de comercializare a unui produs sub un nume asemănător cu cel al unei mărci renumite, în scopul de a crea confuzie în rândul consumatorilor. Deci, care sunt cele mai contrafăcute mărfuri? Contrafacerea afectează în prezent întreaga gamă de produse existente pe piață, cum ar fi produsele alimentare și băuturile alcoolice, parfumurile și încălțăminte de firmă, ceasurile, jucăriile, produsele software și chiar pietrele prețioase și altele. Deci, practic, tot ce se vinde are un echivalent contrafăcut, iar falsurile se întâlnesc la tot pasul. De multe ori, însă, produsele contrafăcute sunt atât de bine realizate încât, la prima vedere, pot induce în eroare. Deci, mărcile contrafăcute pot avea oarecare efecte sociale, cum ar fi, în urma administrării anumitor medicamente contrafăcute, chiar dacă acestea nu duc la intoxicație sau decese, ele facilitează o rezistență microbiană, ceea ce poate degenera în epidemii, subminând lupta împotriva bolilor infecțioase. De asemenea, consumarea produselor alimentare și a băuturilor alcoolice contrafăcute poate duce la intoxicații în forme agresive care pot degenera în decese. Este cazul acelor produse care conțin aditivi ilegali de o toxicitate ridicată, nerecomandați pentru consumul uman. De asemenea, conform opinii exprimate de profesorii în criminologie David Weil și Joanna Large, într-un studiu realizat în anul 2010, produsele de lux contrafăcute nu prezintă un pericol pentru sănătatea publică. Însă, cu toate acestea, nu trebuie neglijat faptul că producția acestor bunuri are loc de regulă în condiții de muncă în care angajatorii nu respectă normele de securitate a muncii, iar lucrătorii sunt expuși la diferite riscuri de accidentare și îmbolnăvire profesionale, cum ar fi asociate unor factori de risc chimici, fizici, mecanici, electrici, ergonomici și alții. De asemenea, contrafacerea mărfurilor poate avea și anumite efecte economice. Deci, fabricanții de produse originale înregistrează scăderi în vânzări și respectiv pierderi materiale din două considerente. Primul, că produsele lor originale sunt concurate de altele falsificate, care pot fi de calitate mai slabă, oferite pe piață la un preț mai mic, deci cumpărătorul achiziționează și astfel de produse în loc să procure dintre cele autentice. Și, de asemenea, cumpărătorii care au achiziționat produse de o anumită marcă, constatând slaba calitatea acestora, ori nesatisfacerea propriilor cerințe, renunță în a mai achiziționa pe viitor produse din marcă respective, fără să ia în calcul de cele mai multe ori și varianta că a achiziționat un produs contrafăcut. De asemenea, există și anumite efecte juridice. Potrivit articolului 185, alineatul 2 din Codul Penal al Republicii Moldova, este interzis prin lege utilizarea fără consimțământul titularului a mărcii protejate sau unui semn care, din cauza identității ori similitudinii cu marca înregistrată și a identității ori similitudinii produselor sau serviciilor acoperite de semn și de marcă, va genera riscul de confuzie în percepția consumatorului, precum și comercializarea ori stocarea lor în acest scop, sau după caz oferirea ori prestarea serviciilor sub acest semn, precum și importul sau exportul produselor contrafăcute, se pedepsește cu amendă de la 1150 la 1350 de unități convenționale sau cu muncă neremunerată în folosul comunității de la 180 la 240 de ore. De asemenea, contrafacerea are multiple efecte negative directe și indirecte asupra tuturor actorilor economici. Cum ar fi asupra producătorilor, impactul negativ al contrafacerii este direct. Din cauza produselor falsificate, producătorii pierd venituri. De asemenea, contrafacerea are efecte negative și asupra consumatorilor. Aceștia cumpără un produs care e puțin probabil că îi va satisface așteptările ca și produsul original, iar în unele cazuri produsul chiar le poate dăuna. Pentru stat, contrafacerea se manifestă în pierderi ale veniturilor fiscale prin mărirea ratei șomajului. Din cauza că producătorii de falsuri de regulă nu plătesc impozite, iar producătorii de produse originale, din cauza pierderii de venituri, pot recurge la micșorarea volumului producției și respectiv la disponibilizarea personalului. Și, de asemenea, contrafacerea nu este benefică nici întregii societăți în ansamblu, deoarece are un impact negativ și asupra investițiilor în cercetare și dezvoltare. Adică un producător care pierde venituri din cauza falsurilor este descurajat să mai investească în elaborarea produselor noi și respectiv piața degradează. De asemenea, există anumite sfaturi utile pentru a evita mărcile contrafăcute, cum ar fi informarea despre produsele pe care dorim să le procurăm, evitarea locurilor dubioase de comercializare, cum ar fi piețe sau tarabe, verificarea ambalajului care trebuie să fie intact, fără anumite greșeli ortografice, evaluarea prețului. Dacă prețul produsului este unul mic, atunci probabil că produsul dat nu este unul original. Și cererea tuturor documentelor confirmatoare că produsul dat este original. Și în concluzie pot afirma că fenomenul contrafacerii se dezvoltă continuu, demonstrând cât de profitabil poate fi, cât de mare este vanitatea oamenilor, cât de mare poate fi magia produselor contrafăcute, cât de ușor se lasă oamenii pradă produselor contrafăcute și cum acestea reduc vânzările firmelor legitime și privează guvernele de veniturile atât de necesare, ele reprezentând riscuri clare pentru sănătatea și siguranța celor care le utilizează. De aceea trebuie să fim foarte atenți la ceea ce procurăm. Vă mulțumesc pentru atenție.
Mulțumim, Santa Maria. So for English-speaking attendees, she was presenting about counterfeiting goods, and she started with mentioning the fact that the most oftenly counterfeited goods were watches, shoes, bags, cosmetics, but also digital gadgets. Then she proceeded with presenting social effects of counterfeiting, especially relying on that damage on health of the consumers of these counterfeited goods. Then she mentioned about, even though in some studies counterfeited goods are of luxury goods, especially are not hampering the health of consumer, but researchers invite, let's say, consumers of these counterfeited goods to think about the abuse of use of low labor force in producing these goods and the conditions in which are forced this labor force to work. Then she focused on juridical effects, mainly mentioning about the law that is regulating the punishment and fines imposed to those that are counterfeiting goods. And of course, at the end, she said about the effects on the consumers, the effects on the government, on the state budget, as well as the effects on the producers. And at the end, in conclusion, she mentioned about the size of counterfeiting nowadays and the importance of analysis of counterfeited goods. Eu am o întrebare la tine, Santa Maria. Dacă poți să ne relatezi niște cazuri reale, da? Studii de caz de identificare a bunurilor contrafăcute și care a fost sentința sau cum s-a soluționat cazurile.
Din păcate, nu am căutat așa informații.
Okay. So I just asked her whether she can come up with some case studies of identifying counterfeited goods and how these case studies were let's say solved. Yeah. We do have one presentation left, and I do invite Crețu Ecaterina from the Academy of Economic Studies of Moldova with her presentation on unloyal competition in the field of intellectual property. She also will present in Romanian, but will proceed in the same way. At the end, I will make just a summary in English. Crețu Ecaterina, vă rugăm.
Da, bună ziua! Îmi cer scuze, se vede prezentarea?
Da, pune numai pe slideshow, da.
Da, o clipă. Tema mea este concurența neloială în domeniul proprietății intelectuale. Mai întâi de toate voi începe cu noțiunea și despre un citat care a fost scris de către un marele părinte al economiei moderne, Adam Smith, în lucrarea sa Avuția Națiunilor, prin care a reflectat o tratare metaforică a concurenței, dar foarte reprezentativă, cum ar fi concurența reprezintă pentru lumea industrială ceea ce reprezintă soarele pentru lumea fizică. Noțiunea de concurență neloială este orice acțiune realizată de întreprinderi în procesul concurenței în care este contrară uzanților oneste în activitatea economică. Din definiția dată, putem reflecta următoarele caracteristici sau ca obiecte de bază ale concurenței neloiale, ceea ce este buna credință, etica în afacere, moralitatea și onestitatea. Datorită dezvoltării științei și industriei, ideile teoretice despre natura concurenței au trecut printr-o anumită evoluție, prin care importanța economiei pentru dezvoltarea economiei este recunoscută și la ora actuală. Concurența este una dintre cele mai importante elemente care formează baza funcționării unei economii moderne și asigură dezvoltarea relației de piață. Fenomenul concurenței și proprietatea intelectuală interacționează într-un proces complex al economiei de piață, având drept rezultat asigurarea egalității tuturor subiecților și valorificarea nestigherită a propriei creații intelectuale. În cadrul economiei pe piață de activitate a subiecților se desfășoară sub anumite semne distinctive, adiționale, denumiri de firmă, fie ele formate într-o coloană sonoră, un text, un desen, un model sau altele, chiar poate fi constituite la un loc, ceea ce pot fi combinate. Aceste semne distinctive reprezintă creații intelectuale concepute special pentru individualizarea subiecților față de alții și totodată pentru a le evidenția specificul activității. Potrivit legislației, obiectul proprietății intelectuale include următoarele rezultate ale activității intelectuale. Acestea pot fi obiecte de proprietate industrială, cum ar fi invenții, mărci, desene, modele industriale, indicații geografice, denumiri de origini, specialități tradiționale garantate, soiuri de plante, topografia ale circuitelor integrate. Și a doua fiind obiectul dreptului de autor și drepturilor conexe, acestea pot fi opere literare, dramatice, științifice, muzicale, de artă plastice, fotografice, de artă aplicată, de arhitectură urbanistică, artă fotolică, programe pentru calculator, bază de date, opere integrate, derivate audio-vizuale, fonograme, videograme, interpelări, opere coreografice și panoramice, emisiunile organizatorice de difuziune. Concurenții neloiali, dorindu-și la rândul său să aibă o clientelă numeroasă, respectiv profitul substanțial, este că să furie din beneficiile prestigiului unele semne distinctive. Întreprinderea care activează pe o anumită piață relevantă propune bunuri și servicii sale sub un nume special, având interesul legitim să valorifice pe deplin reputația acestui nume. În asemenea situații, titularii dreptului de proprietate intelectuală au la dispoziție o gamă variată de mijloace de apărare. Unele dintre acestea este apărarea drepturilor pe cale administrativă și anume prin depunerea unei plângeri la Consiliul Concurenței. Consiliul Concurenței nu are atribuții directe referitoare la proprietatea intelectuală, însă este autoritatea care, potrivit articolul 39, litera A legii concurenței numărul 183 din 2012, constată comiterea unor încălcări ale legislației din domeniul concurenței, ajutorului de stat și publicității. Unei asemenea domenii al concurenței care implică drepturile asupra proprietății intelectuale este concurența neloială. Însă, în conformitate cu prevederile articolul 4 al legii concurenței, concurența neloială reprezintă orice acțiune care este realizată de întreprindere în procesul concurenței, care este contrară uzanților oneste în activitatea economică. Legea concurenței numărul 183 prevede enumerarea, dar și descrierea succintă a următoarelor acte de concurență neloială, cum ar fi discreditarea concurenței. Discreditarea concurenței în Republica Moldova poate avea doar prin două modalități. Aceasta este discreditare indirectă, care constă în răspândire de către o întreprindere a informațiilor false despre produsele și activitatea sa, iar cea directă constă în răspândirea de informații false despre produsele și activitatea unui concurent. A doua fiind instigarea la rezilierea contractului cu concurentul, care este prevăzut la articolul 16 al legii concurenței numărul 183, care în Codul Civil Modernizat al Republicii Moldova, care este intrat în vigoare din 1 martie 2019, are loc o modificare de ordin terminologic, cum ar fi instigarea la rezilierea contractului cu concurentul, este înțeles ca instigarea la rezoluțiunea contractului cu concurentul. A treia fiind obținerea și sau folosirea ilegală a secretului comercial al contractului cu act de concurență neloială, care este prevăzut la articolul 17 din legea concurenței numărul 183 din 2012, aceasta fiind la rândul său, în primul rând, se interzice obținerea și sau folosirea ilegală de către o întreprindere a informații care constituie la rândul său un secret comercial a unui concurent, care este realizat fără consimțământul lui, dacă aceasta a adus sau poate aduce atingerea intereselor legitime ale concurentului. Respectiv, secretul comercial este o formă importantă de proprietate industrială. Secretul comercial în cadrul proprietății industriale se protejează prin diferite modalități, ca de exemplu ar fi brevetul de invenție sau în cazul în care este dezvăluite anumite soluții tehnice utilizate. Cel de-a patra fiind deturnarea clientelei, care este prevăzută la articolul 18 al legii concurenței numărul 183 din 2012, la rândul său, întreprinderea poate induce în eroare consumatorul cu privire la natura, modul de fabricare, precum și la cantitatea, prețul de calculare a produsului. Respectiv, criteriile de bază a deturnarea clientelei concurentului este la rândul său modul și locul de fabricare a produsului, în care aici la rândul său se pune accent pe tehnologiile care sunt utilizate și în al doilea rând pe materialele componente. A doua fiind caracteristicile principale a produsului, aici la rândul său se referă la cantitatea, orașul și regiunea în care este produsă și prețul produsului în care se face o modalitate de calculare a produsului, precum și prețul concret al produsului. Cea de-a cincea formă fiind confuzia. Confuzia este prevăzută la articolul 19 al legii concurenței numărul 183 din 2012. Toate acțiunile ale concurenței neloiale menționate, într-o măsură mai mare sau mai mică, pot fi comise în daune drepturilor de proprietate intelectuală, precum și a titularilor acestora. Însă acțiunea de concurență neloială, care de fiecare dată implică o atingere a drepturilor de proprietate intelectuală, este confuzia. Este prevăzută la articolul 19 al legii concurenței, cum și am mai menționat, în care relatează: sunt interzise orice acțiuni sau fapte care sunt de natură să creeze prin orice mijloc o confuzie cu întreprinderi, produsele sau activitatea economică a unui concurent care este realizată prin folosirea ilegală, integrală sau parțială a unei mărci, embleme de deservire, denumiri de firmă, a unui desen sau model industrial, precum și alte obiecte ale proprietății industriale, de natură să creeze o confuzie cu cele folosite în mod legal de către o altă întreprindere. Și doi fiind copierea ilegală a formei ambalajului sau aspectului exterior al produsului unei întreprinderi și plasarea produsului respectiv pe piață. Copierea ilegală a publicității unei întreprinderi dacă aceasta a adus sau poate aduce atingere intereselor legitime ale concurentului. Consecințele păguboase ale confuziei pot fi luate în considerare la stabilirea amenzii. Totodată, legea concurenței impune și niște condiții stricte ale titularului de drepturi de proprietate intelectuală care sesizează Consiliul Concurenței și pretind apărarea drepturilor încălcate. Condițiile care trebuie să fie întrunite pentru apărarea proprietății intelectuale prin prisma legislației concurenței neloiale sunt: prima, pot solicita apărare de la Consiliul Concurenței a drepturilor de proprietate intelectuală doar întreprinderile, respectiv eu am inclus aici definiția întreprinderii, însă nu voi da citire. Produsele care sunt cele menționate sunt bunuri, lucrări, servicii, inclusiv și serviciile financiare care sunt destinate vânzării, schimbului sau alte modalități de includere în circuitul civil. Conform practicii Consiliului Concurenței, schimbul sau au fost aduse în calitate de întreprinderi pe cazuri de concurență neloială organizațiile de gestiune colectivă a drepturilor de autor și cele conexe, chiar dacă acestea sunt persoane fizice fără scop lucrativ. Și a doua, fiind Consiliul Concurenței poate examina un caz de concurență neloială doar la solicitarea întreprinderilor afectate pe măsura încălcare a legii, astfel titularul drepturilor de proprietate intelectuale pretinse afiliate nu beneficiază de o protecție autonomă. Aceștia urmează să se adreseze autorității de concurență. Respectiv, vor depune o plângere privind presupusele acțiuni de concurență neloială. Aceasta, la rândul său, trebuie să întrunească toate condițiile, precum și formele care sunt incluse prin hotărârea Plenului Consiliului Concurenței numărul 8 din 2012, în cazul în care este scrisă o simplă sesizare sau o simplă solicitare de protecție a drepturilor de proprietate intelectuală, respectiv ea nu va fi admisă, pentru că este o informație detaliată despre concurență și presupune încălcarea legii, ceea ce prevede interesul legitim, precum și probe trebuie să conțină. O condiție importantă pentru apărarea dreptului de proprietate intelectuală de către Consiliul Concurenței este respectarea termenului de prescripție de 6 luni pentru depunerea unei plângeri. Conform articolul 14, alineatul 5 și alineatul 6 al legii concurenței, întreprinderea al cărui interes legitim a fost lezate poate înainta plângerea privind presupusele acțiuni de concurență neloială la Consiliul Concurenței, termen de 6 luni, de la data la care a fost cunoscută sau ar trebui să cunoască despre realizarea presupuselor acțiuni de concurență neloială de către o altă întreprindere. La fel, expirarea termenului de 6 luni constituie un temei de refuz pentru Consiliul Concurenței de examinarea plângerii, dar nu creează un impediment pentru adresarea în instanță de judecată. În urma examinării unei cauze concurențiale, Consiliul Concurenței poate lua următoarele decizii. Prima fiind încetarea investigației cauzei. 2. Fiind constatarea comiterii acțiuni de concurență neloială. 3. Impunerea măsurilor de încetare a acțiunilor de concurență neloială. Și 4. Fiind aplicarea sancțiunilor întreprinderilor care au comis o acțiune de concurență neloială. Aici am prezentat un caz practic în care o companie din Republica Moldova a fost amendată de către Consiliul Concurenței pentru că a copiat ilegal ambalajul unor produselor comercializate de către o companie ucraineană. La Consiliul Concurenței a fost depusă o plângere de către Tim Cabodiu, care este avocat din cadrul biroului asociat de avocați Efrim Roșca și asociații, în numele întreprinderii Tristar, SRL, Ucraina, privind presupusele acțiuni de concurență neloială realizate de către o întreprindere cont asistență relea. În plângere au fost invocate presupuse acțiuni de concurență neloiale realizate de către întreprinderea cont asistență. Realizarea prin copiere ilegală a ambalajului produsului de halva al întreprinderii Tristar, produsul sub marca comercializată Salatoi Vechi și plasării produsului respectiv pe piață. Compania respectivă a anunțat că a renunțat la acest ambalaj și că a elaborat unul nou. Totodată, întreprinderea s-a plâns că după inițierea investigației a suportat cheltuieli importante și este în prag de faliment. În aceste circunstanțe, Consiliul Concurenței a decis să-i aplice o amendă în sumă de 909 lei. Un exemplu teoretico-practic la fel, care conține abordări valabile pentru forma ambalajului și aspectul exterior al produsului. Toți cunoaștem Societatea pe acțiuni Bucuria, precum și SRL-ul Nefis, în care, potrivit unei decizii emise de către Consiliul Concurenței, în care Bucuria a depus o plângere împotriva întreprinderii Nefis SRL, deoarece întreprinderea dată manifesta o copiere ilegală a ambalajului de produse de bomboane la cutia, care este meteorit de 320 de grame, meteorit de 400 de grame și Chișinăul de seară. Respectiv pentru produsele sale, care sunt similare cu 5 minute, furtună și prună delicioasă. Și a plasat respectiv produsele de cofetărie pe piață. Astfel, în consecință, Consiliul Concurenței a decis ca Nefis a întreprins o acțiune care sunt de natură să creeze o confuzie cu întreprinderea Bucuria și cu produsele de cofetărie prin copierea ilegală a ambalajelor de produse care le-am menționat, precum și plasarea acestor pe piață. Acțiunea dată fiind în stare să dea anumite atingeri intereselor legitime ale reclamantului și a aplicat o amendă în mărime de 152.000 de lei și 24 de bani. Instrumentele juridice de contracarare a acțiunilor de concurență neloială pentru combaterea acțiunilor de concurență neloială este la rândul său prevăzute două modalități. Prima fiind obligarea încetării acțiunilor de concurență neloială și a doua fiind aplicarea sancțiunii. La fel am dat un exemplu, dacă o întreprindere a fost găsită vinovată pentru o acțiune de concurență neloială și ca urmare a constatării a fost aplicată o amendă administrativă, bazându-și pe principiul non bis in idem, regula potrivit căruia o persoană nu poate fi urmărită sau judecată de două ori pentru aceeași faptă. Nu ar fi susceptibilă tragerea la răspundere penală, respectiv aplicarea pedepsei penale sub formă de amendă. Tipuri de răspundere pentru încălcarea legislației concurenței neloiale. Eu am dat aici un pic explicare. Răspunderea civilă în care se realizează în cazul comiterii delictului de concurență neloială, care este prevăzută la rândul său în Codul Civil al Republicii Moldova. Răspunderea administrativă care se realizează în baza legii concurenței, în care un for de specialiști din domeniul numit Plenul Consiliul Concurenței examinează cazuri de concurență neloiale și decid dacă există concurență neloială sau nu și deja individualizează cuantumul amenzii care urmează a fi aplicată. Și răspunderea penală în care legiuitorul a adoptat prin legea penală un sistem deschis de contracarare pe calea tragerii la răspundere penală a concurenței neloiale, în care este prevăzut la articolul 246 prim, în care este denumit ca orice act de concurență neloială. Codul penal, la rândul său, reglementează două măsuri de contracarare a concurenței neloiale, prima fiind aplicarea amenzii pecuniare și a doua fiind închisoare pentru persoanele fizice. Și ca concluzie, în cadrul cercetării efectuate, am avut posibilitatea de a evidenția unele tendințe și legi generale privind concurența neloială în domeniul proprietății intelectuale. Prima fiind, proprietatea intelectuală reprezintă un atribut esențial al economiei de piață, dezvoltarea pozitivă a căreia este bazată inclusiv pe un mediu concurențial corespunzător sub aspect de stare, structură și dinamică. În același sens, concurența este unul dintre cele mai importante elemente care formează baza funcționării unei economii moderne și asigură dezvoltarea relației pe piață. Astfel, fenomenul concurenței și proprietatea intelectuală interacționează într-un proces complex al economiei de piață, rezultatul fiind asigurarea egalității tuturor subiecților și valorificarea nestigerită a proprii creații intelectuale. Prin urmare, Consiliul Concurenței este autoritatea care acordă susținerea întreprinderilor prejudiciate de acțiunile de concurență neloială în apărarea drepturilor de proprietate intelectuală. Aplicarea amenzilor întreprinderilor vinovate și obligarea acestea să întreprinde toate măsurile pentru a înceta acțiunile de concurență neloială reprezintă mijloacele prin intermediul căruia autoritatea de concurență asigură protecția drepturilor de proprietate intelectuală încălcate. Vă mulțumesc pentru atenție.
Așa, mulțumim, Ecaterina. Dacă poți face întrerupere de ecran. Ok. So, as promised, yeah, I know that the others are already finished and they joined us for the closing session. But as promised, just a few words about the main ideas that were presented by Ekaterina. She was presenting about unfair competition in the field of intellectual property protection. She started with explaining and defining what is unfair competition. And she mentioned about that competition law currently does not refer to directly to the protection of intellectual property rights. But she mentioned about the use of these issues in discrediting competitors, instigation in the execution of the contract, use of obtaining illegally of a commercial secret, but also confusion that is created by the unfair interrelations between unfair competition and IPR. By mentioning that also the laws applicable to any of this effect. At the end, she presented two case studies specifically. The first one was on a company that complained to the competition committee about the other copying the design of the package, and the other one, the first case was between one company from the Republic of Moldova and the other one from Ukraine. And the second one was between the two companies producing sweets also the one complaining or the other of copying, were adopting the same style of design in their packages. So she closed with mentioning the provisions of national legislation for unfair competition and where it interferes with the field of intellectual property rights. Yeah, thank you very much to all attendees. We gathered together for a closing session of our conference. Probably because I was moderating the panel one, I will just briefly summing up and wrapping up what we did in this panel, and later on I'll give the floor to my colleagues that moderated the two other panels, just all of us having the entire picture. So I've started mentioning that our discussions were mainly held in English because of the presence of international speakers. So our panel focused on competition, intellectual property right, and consumer protection. So we started with the main, let's say, headlines of competition policy, intellectual property right as cornerstones of efficient market. Then we moved to another very insightful presentation of our Ukrainian colleague from University of Ivano-Franko National University of Lviv, on the interference between the three coins of that lead to influence the economic growth, and namely intellectual property that stands for the innovation capacity of a country, then competition and intellectual and consumer protection. She went through the main, let's say, performances of all Eastern Partnership countries. She mentioned about the differences between the countries that do have an association agreement with the European Union and how the legislation stands in this regard compared with other countries in Eastern Partnership agreement. Then we had a presentation from our colleague from Shevchenko Transnistrian University on improving the practice of competitive strategies for protection of intellectual property rights, with presenting some global trends in the field of protection intellectual property rights index. Then we have a more practical, let's say, and a comparative analysis of protection of intellectual property rights, but also the investments in the research, yeah, as a trigger for intellectual property overview. So a comparative analysis between Czech Republic and Poland, a paper that was drafted by the two representatives of these countries. Then we had a very interesting presentation on discrediting and denigration of competitors and how they are using different strategies to gain the market, and how they are using trademarks to discredit their competitors. Then we continue with trademarks by another presentation explaining the role of trademark in promoting the goods, also in the competition fight for consumers and market share, and we ended up with discussions in counterfeiting the goods and unfair competition. So you were listening to my comments at the end. So in short, we had really fruitful debates. So very, very interesting research results that are worth to be considered for publishing. Thank you once again for everyone to this panel. Now I want to give the floor to my colleague Natalia Mogul, which was moderating the second panel. Natalia.
Thank you, Radhika. Good afternoon to all of you again, because we went into our second panel. I will briefly describe what we have discussed there. I just want to say from the beginning that I am really pleased that I moderated this panel. I am sure that the two other panels also were interesting, but our it was really interesting because we had a very diverse auditoria. I mean, we had at the beginning best practices, let's say, from Bulgarian side, and after that a short presentation of the Court of Justice cases by the representative of the Ivano-Frankovsk National University. And after this, we had this very comprehensive presentation provided by our colleague from the State Agency on Intellectual Property, which offered an overview of the copyright protection system in the Republic of Moldova. And after we listening with the huge interest for the presentation of Mr. Badiku Yuri from the private sector, which presented its view of the copyright system and of the ways to valorize their creativity, and it was very interesting. And after that we had the three magnificent students which presented their view, and we encouraged them to continue to make their research in the field of copyright, which is a very speedy evolving field. And just as at the beginning in the plenary was mentioned that we have already these discussions about the artificial intelligence in the copyright, but not only in the copyright, but in the intellectual property as a whole. So we managed to discuss very different aspects of the copyright protection. And from my point of view, and correct me if I am wrong, colleagues from the panel too, but from my point of view, we managed to hold a very fruitful discussion on this issue, and I am sure that we will continue to discuss it after this, and for sure those papers presented during our panels are worth to be published, yeah, for sure. So just in brief, thank you.
Thank you very much, Natalia, for this wrapping up session. Now I want to give the floor to my colleague, Olesya Plotnik, that was co-moderating the third panel. Am I right, Olesya? Are you presenting the wrap-up session? Or,
thank you very much. No, it's okay. Thank you very much, Radhika. As I was moderating our section in the second part, I want to say that we were pleased to know that the people were involved in the research of intellectual property rights. More than less, we was able to establish that there is a good correlation between consumer protection and intellectual property rights. More than less, I informed all our participants that they have a possibility to publish their articles in our journal, that will be soon. More than less, I made a short presentation about the advantages to be member of the association Henri Capitan. And we hope that this kind of organization of conference Jean Monnet within project Erasmus Plus, it will be a tradition, and we hope to meet all our participants next year, because each spring in March, so we organize this kind of conference in partnership with our partners and of course with our experts. Thank you very much, and Mr. Cimil, maybe he also may say something. Thank you.
Ok, eu o să vorbesc în limba română, fiindcă auditoria este și cu participarea persoanelor care au vorbit și au prezentat în limba română. Îmi exprim gratitudinea pentru colegii de peste hotare, în special invitați și care au adus în discuții teme absolut importante, și vreau să remarc aici nu numai juriști, dar și politologi, medici, deci sociologi și chiar economiști. Deci am avut o gamă largă de profesii care au adus lumină asupra unor probleme de implementare a legislației și de apreciere a valorii mărcilor, aprecierii a valorii, deci altor semne de distincție sau de punere în circuit a acestor produse. Iar un semnal a fost tras de către doamna doctor Iuliana Lupașcu, care a venit cu un mesaj to be or not to be, fiind îngrijorată de lezarea unor drepturi asupra creațiilor intelectuale din partea medicilor. Deci această problemă este una alarmantă, credem noi, și urmează fi soluționată de rând cu Agenția de Stat pentru Protecția Drepturilor Intelectuale și considerăm noi că urmează mai profund să ne aplicăm asupra celor invocate de către doamna doctor. La rând, felicit și studenții care au făcut prezentări frumoase și profunde în domeniul evoluției economice a mărcilor și au făcut un pas, un început de lansare științifică sau de participare în conferințe naționale și internaționale. Apreciez panelul 3 ca unul absolut interesant și divers și de o înaltă valoare științifică. Vă mulțumesc!
So I'll just briefly mention what has been said for our international speakers. Mr. Cimil also said that their panel was mostly, they do have a lot of presentations on trademarks and a lot of discussions in there. They had also, I mean, professors that are well established and heavily researching this field, but also some young researchers. He also mentioned about the idea promoted by one of the speakers, to be or not to be, from the perspective of respecting the right of intellectual property right, especially in the field of performance and copyright. As a conclusion, he said that he's declaring satisfied about the presentations, both as quantity as quality, the aspect that were addressed in their presentation, and he also reassured the high value of the content and debates. So, in short, I want once again to thank my colleagues, for contributing to the moderation of the panels. I want to thank everyone, especially those that are stronger than anyone that resisted till the end. I know that it's Friday. I know that it's the end of the week. We are living in not in very easy times. So therefore, I do think that those that manage to be present till the end are the bravest. So I want to thank everyone for your commitment, for your active participation, for sharing your research results, for contributing to the success of this conference. And once again, I want to reiterate the possibility of getting published your research results. So please take a look once again to the information that we have displayed both on the website, on the registration form, or we can send once again an email reminding with the publication opportunities after the conference. Thank you once again. And one more favor I want to ask to everyone. Usually when we do have conferences like this or events like this, we have a group picture at the end of the event, taking into consideration that we cannot meet each other face in face, but we are using digital platforms for this. I do encourage at the end everyone to switch on the camera and let us having a few screenshots with everyone. So if you don't mind, please switch on the microphones and we'll use this opportunity to take some screenshots. Thank you. Thank you. A few more. Smile, please smile. So we'll use this for disseminating our conference. So because we are on 3 pages, you have to be patient. So you'll take a little bit of time for me. Okay. So one more. So even though they do not have switch on the camera, smile. You never know. And we had short.
There are more people.
Yes. So that's fine. I managed. Thank you, everyone. Thank you once again for this fruitful conference. We do invite to follow us on our web page or on our Facebook page. And we do invite to take part in all the other activities that we do organize. Thank you, everyone. Have a nice weekend. Stay safe and be healthy.
Thank you. Be safety.
Thank you.
Thank you very much, Rodica.
Take care.
You are the best. Bye.
Thank you. Thank you to you for everything. It was nice. Bye.
Thank you very much.
Bye.
Thank you very much.
Thank you.
Thank you.
Hope to see you next year in Moldova.
Yeah.
Hopefully, and maybe 1 year in
After the
Ukraine.
pandemic times. Yeah.
Yeah. Let's hope that at least for the final year of the project, we'll manage to gather together, face to face.
Let's hope for that.
We hope.
Thank you.
And thank you very much for all our partners. Alliance Française, l'ambassade de France, merci beaucoup pour votre contribution. À très bientôt. Merci.
Je vous en prie, à très bientôt.
Alexandre, nous sommes avec vous. Merci beaucoup.
And of
Et
course, we
félicitations
have
pour
to mention,
le mois de francophonie. Merci.
Yeah, and we have to mention the support of State Agency for Intellectual Property Protection by providing us also speakers and the whole support in organizing this event. Thank you. Thank you.
Welcome. Bye.